Hello everyone, I'm Apurva Pandita and welcome to Livelaw. We all know about the capital punishment and the debate surrounding it. The death penalty, a punishment reserved for only the most heinous crimes, is a topic that continues to stir up strong emotions and opinions. Well, in accordance to Section 354, Clause 3 of the Code of Criminal Procedure, the method for carrying out this ultimate punishment is by hanging the convicted individual by the neck until they are no longer among the living. This process is reserved for only the rarest of the rare cases. While talking about the statistics, the year 2022 proved to be a sobering reminder of the criminal justice system of India, as the trial courts in the country delivered a staggering 165 death sentences, the highest annual total in the last 20 years. The Supreme Court in March had also asked the centre to provide data which may point to a more dignified, less painful and socially acceptable method of executing prisoners other than death by hanging, which means that they called for suggestion of any other methods of execution consistent with human dignity, well, other than death by hanging. We have a separate video covered on this news story which will be available in the description box below. Do not forget to check that out. And talking about the most recent event, the President of India, that is Draupadi Murmu, has affirmed the death penalty of a man convicted for a heinous crime, which means that the President has rejected his Mercy Petition. And this isn't just any ordinary rejection. It's the first time President of India Draupadi Murmu has denied a mercy plea since she took office in July 2022, that is last year. Now, if you're wondering what exactly is a mercy petition, well, in India, when a person is convicted of a crime and has exhausted all legal options, they can turn to the president or governor of their state for mercy. That's right, the highest authorities in the land have the power to grant leniency to convicted criminals. The convict in question, the one that we're talking about today, is Dupare. He was convicted in 2014 for a heinous crime that shook the entire nation to its core. Dupare was found guilty of raping and stoning to death a 4-year-old girl back in 2008. The crime is enough to make your blood run cold. But wait, it even gets more intense. In 2017, when Dupare filed a review petition, the Supreme Court of India had to consider not just the conviction, but also the sentence awarded to him, that is death by hanging. The court considered various principles governing the death penalty, including the aggravating circumstances of the crime, which were pretty brutal in this case, and the mitigating circumstances. Despite his claims of rehabilitation and the mitigation evidence that were presented on his behalf, the Supreme Court of India upheld the death sentence. Let us look into as to what exactly led to the Supreme Court in upholding this death sentence. Why didn't the Supreme Court commute his death sentence to just life imprisonment? Well, with regard to this conviction, in 2017, the court concluded that they had no hesitation in affirming the judgment of conviction delivered by the learned trial judge and affirmed by the High Court. On this issue of death penalty awarded to the petitioner, the court considered various principles governing this issue. The court even referred to decisions such as Furman versus Georgia and Bachchan Singh versus State of Punjab. By keeping in view the various landmark cases and authorities, the court was of the opinion that in the case at hand, that is Dupare's case, not only was the rape committed in a brutal manner, but murder was also committed in a barbaric manner. In favor of the petitioner, it was also submitted that the petitioner is on the path to reformation and rehabilitation, and therefore the death sentence imposed on him deserves to be commuted to imprisonment for life. But despite all the submissions presented, the Apex Court in 2017 had held that they had given anxious consideration to the material on record, but they had found that the aggravating circumstances, namely the extreme depravity and the barbaric manner in which the crime was committed, and the fact that the victim was a helpless girl of 4 years, clearly outweigh the mitigating circumstances which are brought on record. And this is how the court affirmed its 2014 judgment, that is awarding death penalty to Dupare, which was under review and dismissed the review petition. And now in 2023, the President of India, Draupadi Murmu, has made her decision and rejected Dupare's mercy plea. And this brings us to the end of this video. We really hope that you like our content. And if you do, then do not forget to like and subscribe to our channel. And for more legal updates, keep watching Livelaw.